Good afternoon, everybody. Thank all of you for participating. I'm Bob Layton. I'm the city manager, and I am your designated facilitator. My job is just simply to make sure that we have a great open discussion, that we achieve the council objective, and that is to get an acceptable ordinance for their consideration that balances the needs of landlords and tenants. And I think that's really our purpose. I think most of you know this, council would like to have a recommendation back to them for their December 2nd meeting. So I think it's good that we have a deadline. That will kind of keep us moving going forward. I have provided you with an agenda. This came from written and oral comments made during the council meeting. Not meant to be all inclusive, but I'm trying to get at least issues identified and to provide you some framework for the discussion going forward. Before we get started, I think it'd be helpful if we all knew each other and would introduce yourselves. For our new folks, Ann, how are you? Else for you. Maybe starting with my right.
My name is Mike Heldstead. A number of residential properties here in Wichita.
My name is Brady Cyphers. I'm a Wichita Fire Lieutenant. I also own multiple properties, do real estate appraising on the side. So get into a lot of these homes and it felt like I'd be beneficial.
Sure.
My name is Francis Ballman. I'm an attorney at Folsom Siebken. I also own around 505 primarily single family houses in Wichita, and then I'm also the owner of Reliance Property.
My name is Garrett Holmes. I'm an attorney here in Wichita. A lot of our practice is representing a lot of landlords in town.
I'm David Robinson. I'm just a small landlord in Wichita. I'm Pat Daniels. I own and manage residential rental properties in Wichita, and I'm also president of Rental Owners Incorporated, which is the largest independent group of landlords in Wichita.
I'm Eric Maybe. I own Maybe Property Inspections. I'm a property inspector. Third party.
I'm Cody Stout. I'm a regional manager for Wygant Omega Management, as well as I serve as the 2025 president to the Apartment Association of Greater Wichita.
Ann Fox, I'm retired past executive director of Habitat for Humanity and currently on the local and state advocacy committees for housing in Kansas.
Hi everyone, I'm Shiley Ziad. I work for United Way and the Coalition to End Homelessness, and my main role is building and then rolling out the next tenant program. It's for landlord engagement to better partner with property providers and then the service providers that serve tenants.
My name is Paul Gray. I'm a former city council member. I'm a home builder. I have residential and commercial piece, and we have a property management company as well.
I'm Nella Bayouth. I'm the owner of Cedar Mills Property Management, and I also own about 100 units myself, a realtor. Yeah.
So much again for volunteering to work on this project. If it's okay with you, what I thought I would do, you've all been following the process, so we're not going to bore you with a lot of background, but I would like Trey Anderson to give you just a few minutes of what we were trying to accomplish with the International Property Maintenance Code, what the intent was, what were some of the challenges that we thought we had with our existing process that we thought could be addressed through the International Code. So with that, I'll turn it over to Troy. Troy's Assistant City Manager for the city.
So, as far as a little housekeeping, so we are recording as well as live streaming. So there are mics within the room, but feel free to speak up. And so for folks online that maybe tuned in can hear everybody as well. So real fast, 2 minutes background. So we had received a number of complaints, right, that the process as it existed today, that the codes that we have in place subsequent prosecution of violations as it relates to property maintenance and property maintenance codes was not what the community and the governing body and others currently desired, right? That kind of said this in a meeting the other day, right? That what we're doing today is fine. There's sort of nothing wrong per se with what we're doing today. But if we want to do something different, we've got to do something different, right? And so as that challenge was kind of put before us years ago, one of the first things that we did, we started looking into was, and there's sort of three tranches to, or at least our thought process, right? There are the codes and ordinances that the city has to enforce. There's the enforcement process, right? How do we enforce the codes and ordinances that are on the books today? And then ultimately the sort of prosecution side, right? If we're unable to achieve sort of voluntary compliance with the codes and ordinances that we have on the books, right? How does the prosecutorial judicial process play out? We heard some challenges associated with sort of all three of those things, right? And so obviously we try to start at the beginning, which is why we started analyzing the codes and ordinances. The idea was to first better understand how a lot of the codes and ordinances may be outdated, maybe referring to individuals or departments that don't exist anymore, right? And so it becomes sort of convoluted and difficult to enforce and ultimately prosecute. So we started with the codes. One of the options was ultimately to consolidate those various codes and ordinances, which are scattered throughout the city's municipal code. They're in about 4 or 5 different chapters, titles, right? And so one idea, first of all, was to just consolidate all of the property maintenance codes into one section that could be easily referenced, communicated, shared with, et cetera. As that evolved, right, the easiest thing to kind of see that evolution is to look at the International Property Maintenance Code. So the International Property Maintenance Code is a property maintenance code. It's a property maintenance standard. It's part of the International Code Council family of codes. So works really, really well with things like the International Building Code, Residential Code, Existing Building Code, Fire Code, so on. A lot of the code standards that Cedar County and the city have already adopted, right? And so as we dug into consolidation of code, it wasn't a far sort of leap or stretch to simply look at just adopting the International Property Maintenance Code. Anybody that's been involved in any of those adoption of those code series knows that it always comes with local, what they call local amendments. Right. And so that's where over the last couple of years, we've dug into what does the International Property Maintenance Code say, sort of chapter and verse, where are those opportunities to make local amendments to basically maintain what we're sort of already doing today. There's a few variations, there's a few deviations to that, and we'll be more happy to answer any questions as it relates to that, but we felt like we couldn't talk about the enforcement or what we call the standard operating procedures until we landed on the code, right? And we can't really talk about prosecution of enforcement without knowing and understanding what we have, what we've all kind of called a clean code that we can all point back to and look to. So this was just the first step in the process of adopting the code, establishing the codes and ordinances, which are then driving the standard operating procedures, which then addresses the issues with how do we gain compliance, whether that's voluntary or involuntary. But this is somewhat step one, adoption of codes and ordinances. Again, I'll be more than happy to kind of answer any questions you might have on specific code, International Property Maintenance Code or code related questions.
Any initial questions of Troy? I think one of the issues that has been coming up for the entire time that I've worked here is how long it can take a violation, a bad property, to actually be addressed by staff and the courts. And so the International Property Maintenance Code, I think, provides a little more streamlined approach. It's different. And of course, I know that's what you all want to talk about, but I think that's one of the drivers of this. I wanted to mention that Chris Labrum, who's the director of MABCD, and Sharon Dickraff, who is the attorney that helped work on this primarily, are here as resources for you. So if you're okay with this, what I'd like to do is start on the topics. I will say that G and H are listed as topics, but frankly, it may be maybe they are more for you to keep in mind as we talk through all the other issues. I'm not sure there was a speaker that went to the podium that didn't talk about the difference between a good landlord and the small percentage that are bad and are creating difficult situations for tenants. And so I think we should keep that in mind on how do we address those that are creating really unsafe conditions for their tenants. How do we address those and not penalize the whole industry? So I think that's kind of the gist of it. At the same time, how are we mindful of tenants' rights, especially those that are trapped in those really bad situations? So I'm not sure G and H are issues more than overarching considerations for you as you talk through this. So if you're okay with this, this list is meant to be a start. I'm sure there are going to be other issues that you want to add to this, but if we want to maybe jump in to the first item on here, which anybody object to going this direction?
Do we have copies of that?
We probably do have some copies here for the people in the audience.
Just kind of had a general question, just to have a better understanding. I don't know exactly where it'd fall on some of the topics. I don't have any objection to the topics. My understanding in reading the code was that it's also being done in conjunction with eliminating the environmental court. I know that that was one of the proposed ordinances. I didn't hear a motion to continue that ordinance. I know that we're kind of looking at everything here. I know in reading throughout this, and so I just wanted a clarification as to, I know these codes are not eliminating the housing codes that we already have, but they're being added. But also just I wanted to know if that was a part of what was proposed, is eliminating the environmental core, whether that's still on the table, whether that's been done.
Garrett, that is held up for this work. And I think it kind of falls under the C, under the appeals process. So it's really more the adjudication part of all this. If you don't mind, we'll take that up under C.
Heard Troy say that the purpose was to do something different in the areas of code enforcement and prosecution. Is that accurate? And if so, were there like target goals for how these proposed changes were going to impact what outcomes you're trying to get with that? Can you give us one more minute?
Yes, so we often talk about, right, that neighborhood inspection does a really, really good job of working with property owners, landlords, tenants. We achieve, I know I'm gonna get the number wrong, but maybe 85% voluntary compliance, right? At the end of the day, the end goal is compliance, right? Whether it's voluntary or involuntary, the goals are compliance, right? We want to see well-maintained, quality properties, right? And so historically, we've received 85% voluntary compliance on a lot of those issues, right? How we go about that is somewhat debatable, right? And that's something we can talk through. But it's that 15%, right, where we get phone calls, emails, et cetera, of why is this property continually not being addressed, right? Why is this property or that property? Why are we not able to get those properties cleaned up? The violations abated, the issues resolved. Over the last couple of years, you may have seen me and heard me talk about, right, that we absolutely understand property owner rights, right? We talk about property owner rights also have a responsibility to neighbors, right? A lot of the complaints that we receive are oftentimes from neighbors. Hey, we have a dilapidated structure next to us. We have a neighbor that is not maintaining their property. We have tenants that approach us, go, hey, I'm living in sort of substandard condition. And so it's that, call it that 15%. We're trying to do better. How do we do better with responding to property maintenance violations?
So at this point, more ordinances is really the method we've taken. Because things were taken off the table by the council that might have helped with enforcement and courts. So
Are you talking about rental registration or?
the registration, the advanced fines and the multiple conviction kind of process to.
Because this group, that was taken off the table as it was presented. If this group came back with some modified version they thought would help us target the difficult 10%, then I think the council will be open to that, but they rejected it as it was presented. I think, Paul, did you have something first?
I think you just, well, yes, I do. In relationship to this, the Board of Code Standard Appeals has a component of this, and at least they're referenced in here. And when they go to modify applicable codes for the IBC, IRC, and so forth, they usually set up a subcommittee, and they'll work on that in conjunction with the private industry for months to try to come up with the code changes and variations that the city has. I mean, I assume that like one of the big focuses is going to be enforcement and so forth within this group, but the delineation of like getting down to what each applicable code should be for this might be pretty burdensome from this group to try to determine in a month.
Yeah, I get that. And I think if we get through a few meetings and the feeling is that's the case, then maybe what I'll be trying to do is push you towards policy guidance with the understanding that then nuts and bolts, additional meetings will have to be held, maybe with a smaller group of landlords probably. But anyway, we'll have to work through that.
Thanks.
So the question I have is, I've heard this reference, like we don't have 15% compliance, and that's the issue. But what's causing the non-compliant? Like, what is the specific obstacle that's not permitting those cases to be resolved?
I mean, maybe that's a good question for Sharon and for Chris.
Thank you guys. Chris Slater from MABCD. So it is interesting. As Troy said, a lot of our focus is on the voluntary compliance and that. We've actually gotten that up to a high of 88.6% in 24. We're back down to about 87 now. The 12-year average, it's about 85%. And it still is multifaceted because a lot of that is still premise conditions, which we can abate. So you could argue, do we get to that quickly enough or in a way that the community would like us to? But that is one point of that is we are able to clean up junk and trash on properties. We're able to, so if we can clean it, if we can tow it, if we can mow it, if we can board it, or otherwise abate it, we take care of it. A lot of the discussion, as I've seen, comes into where we've kind of already started here is when we have a housing or zoning violation, because I do not have an abatement tool associated with those. So I'm dependent on some form of prosecutory action, followed by potentially a court action to try to get at those. That then starts to open the topic of LLCs that own properties and it's hard to get anyone notified, or out of state, out of town property owners, or those that tend to, through landlord-tenant relations, tend to, the word used, so I will quote it as exploit loopholes or find loopholes, or willing to go to court and spend money there versus spend money on the properties, again, would be the accusations that come with that. So does that hit at?
Kind of, but isn't there a process that you can placard and or condemn a property?
Yes, we can. So condemnations would fall under items that we can abate. We can placard as uninhabitable. So you do see that we will placard a property or a unit maybe as has to be repaired before it can be inhabited. So that is one action we have. Now, a tool that we can and do use is an administrative warrant. So we can get a warrant to deal with a lot of those problem properties. That is, of course, a pretty arduous process. So we are somewhat limited just by staff capacity, funding. But that is one tool that we have available to us, and one that we've looked at through code and through some of this. Is would we want to expand some of those kind of options?
Out of state property owners are even more problematic in that process.
Because I hear that from a lot of people I've talked to in real estate groups and stuff, and everybody's question is kind of similar. Like, we don't see it as a breakdown in process. Like I personally have gone to environmental court when we had a property that wasn't in compliance and we needed time and we got it resolved. But I understand there's people that don't resolve it. So I guess my question, instead of like trying to reinvent the whole wheel, like, could we just focus for a more time sensitive reaction to kind of address those issues to the part that's really lacking? Because I'm concerned that this is so robust. There's so much to it. There's so many people involved that it's going to take even longer. And then some of the things we might implement may even create more bureaucracy. And so, like, what are those tools that you guys would need to be able to say, okay, they didn't show up to court, they may be out of state. So what do we, how do we bridge that little piece of it to where you have 100% compliance eventually?
Sharon DeGraff, City Law Department. I think you have a couple of moving parts here. One is your out-of-state owners. Your other is property that nobody owns. Meaning, I know that sounds kind of silly, but if the owner has died, nobody really wants to probate it. It sits there, their kids are out of state, so you have that group. And then you have a group of people who really just can't afford to fix it. And we have resources through MABCD. We have a great advocate. But if you're talking about mowing and painting, they can probably help you. But if you're talking about fixing the foundation of your house, that's a whole nother area. So I really put these chronic people in kind of three categories. One is I'm never going to fix it because I'm going to make money off of it. Second is I'd like to fix it, but I don't have any money. And then the third one is just the difficulty of finding who's responsible. And you're right, if the property meets certain criteria, we can board it, we can tear it down. Then you create a vacant lot that we end up mowing forever. So you do have that 15% that I think has been the problem. It's just how we address the 15%. If I go back to what Mr. Gray said on the Board of Code Standards piece, the only thing that they're going to get from the IPMC is an appeal from someone who was cited. And it's an appeal process, and you don't have in that code, but in Title 18, it sets up an appeal panel. So there'll be 3 people from the board. So it won't be the whole board, so it won't tie up its other activities. But 3 people would then look at that appeal to say, is there some other mechanism to get compliance? Should the person get an exception up to a year from whatever those particular code requirements are? So it's pretty narrow, but there is an appeal process. There's also an appeal process if I go to court and I get convicted and I don't like it. Currently, they're entitled to a jury trial in district court. So there's lots of levels of appeal. Lots of hands.
While we have legal at the podium, there's a property at such and such corner that from 2011 on, I was trying to get repaired through the process of reporting. And through that, I learned that the owner could be taken to court and they could be convicted and pay a fine even, but never fix the problem. Is that accurate? Is that really how it happens, that people do go to court? And I've heard many out of state people say, oh, it's much cheaper for City of Wichita to mow my grass than for me to hire somebody to mow it. So I just always pay those fines. And it really peeves me. But is it true that we could go through the court process and still never see the actual problem fixed?
The actual sentence is left up to the judge. My staff can ask that it be fixed. My staff can ask that they be put on probation. Currently, I know one of the big concerns was, oh my gosh, they can go to jail. They can go to jail now. Under our current code, does that happen? Very, very rarely. I can count on my hand about 3 people that I'm aware of that have gone to jail. And they had the means to fix the property and the judge was done. So those are the exception rather than the rule. But yes, I mean,
they're in that 15% that
our
we as the
goal,
public.
yes, our goal is compliance. And I think this is one of the things that we have talked about just kind of internally is that still a good model for municipal court? I mean, municipal court takes a long time and I've been here a long time. And when we started e-court, it was, we're going to give you time to fix it. We're going to give you time to fix it. We're going to give you time to fix it. And for some cases, I think that may be appropriate. For other ones, I'm not so sure. And whether it's a more streamlined, more goal-oriented, we're going to shorten those continuances down. We're going to shorten the time that this is in court. I mean, that's something that our office would do internally. But if that is the direction that the city council wants to take, we would certainly consider that in how we approach these cases. But I mean, Chris is right. The easiest way to fix these is if we go in and fix them. But then the city is at the expense of fixing those. And I can't repair the foundation of your house. I can mow your grass. I can get the cars won't move. So the nuisance abatement is one arm. And then you have the housing structural problems on the other, which is, I think, one benefit of the IPMC is that it morphs all those together. And our code is kind of a Frankenstein code, and I wrote most of it. And that's because we had a health department, and then we had an ABCD, and then we had something else. So we've had different versions of who we wanted to do what over the last 33 years that I've been here. And the code reflects that.
You're not just talking rentals though, you're talking vacant properties.
Oh, yeah, no, I'm not talking just rentals. I'm talking homeowners or.
And you plan on applying this to everything then, not just rentals?
Yeah, no, the code, as all our codes do now, would apply across the board. Yes.
Yeah, this might be a question for Chris, so, or for both of you, but currently within the tool belt of MABCD, do they have the authority to go in and fix these properties, or it really is just the fines, some of those penalties, and they can't really step in outside of condemning a property? You can do that, but when it's maybe not at that level, but there's just non-compliance, what authority does MABCD have currently?
So currently now, I would prefer to share this if we have the authority to do that, because if I go get a warrant or a court order, there's a lot we can do. But currently our policy is we do not repair. So we would abate. Now voluntarily, as Sharon pointed out, we have code liaison programs. So when we get into situations of age, income, health, et cetera, we have 2 social workers on staff. And we have a lot of volunteers. We have a long list of volunteers that help mow yards. The high schools actually come out and do several alleyway cleanups and also help us paint houses each year. So there's quite a bit of work that takes place there. But aside from voluntary, as it stands today, we do not enact any maintenance or repair, et cetera, as an abatement action. So kind of back to what Ann brought up, as it looks to us, and again, Sharon's my prosecutor, lead prosecutor, even with these, so we kind of defer to there, but there's very much a difference in my world between adjudicated and corrected. Because once something goes to court, that's a process in and of itself with due process. I want to be careful here, but there's an element of start over there or start fresh because they're innocent until proven guilty. So depending on how that goes, that can be adjudicated in a method that the judge sees fit, where you as a neighbor or you as a tenant or whatever may feel that you still have a very valid complaint and that the property correction has not been made. We may feel the same way. So then we would have options to start that into process again.
So would the judge, with the new process, be able to match what's needed to meet the housing codes? Either,
Why don't we outline the new process so everybody's clear on how that works?
As far as the new process, we don't have the actual MABCD processes completed, but it's gonna look much like it does now. They're gonna go out, they're gonna do an inspection. Depending upon the type of violation, they can, but don't have to give the person time to fix it before they proceed with a actual citation. And I think the reason for that is to give them some sort of an option. If I have a repeat offender, if I have somebody that has 5 properties and all 5 properties have issues and we've told them what all the issues are and they don't do anything, do we have to give them that 30 days, 60 days, 90 days to get it fixed before they get into court? They could proceed with a uniform criminal complaint. That complaint then would trigger a right to an appeal if that individual wanted an appeal to go to the Board of Code Standards and Appeals. If they did not, then it would proceed to the court system as it normally would, with the direction that's in the beginning of the IPMC that it's the council's direction that we proceed with these in a timely manner through court. And then again, if they were convicted, they could appeal it to district court if they were convicted.
I did have a question on the UCC. What would they appeal? Because the property is either compliant or not compliant on the day it's issued. It's a binary. I mean, there's only one way. It was either compliant or it was not compliant. And I don't see a code inspector issuing that if the property was compliant on that day.
I think the appeal process is, I mean, there's currently an appeal process now with, if I'm the citizen and I don't think that Chris is interpreting the code correctly, or I think this code inspector may be overzealous, so that intermediate appeal exists there now. The secondary appeal to the Board of Code Standards is to give a real exception in those cases that I can't quite bring it into compliance, but I could do A, B, and C. Or I need an exception of up to a year to bring it into compliance. So it's kind of an off ramp, which is what the council had wanted, of some sort of administrative process to get those cases that truly I can't afford to do it, or I need more time, or I'm looking for resources that it could go to this off ramp.
What's written into the code is pretty black and white and draconian. It would have helped a lot if there had been some of these off ramps and levels of appeal, because it's hard to quantify anything in just black and white words. So, I mean, it's nice to have that, you know, no 2 cases are ever the same.
No, they're not.
Well, sir, if I may point out, one thing we discussed the other day is for the board, what was published in association with the agenda are the amendments. So I think it's important for this group to take into account that there's a baseline IPMC that matches with that you have access to, so to ensure that all that's looked at now. And something Sharon reminded me of, I thought of when you were asking questions and kind of forgot, is so when you look at our percentages and what we look at, as Sharon was kind of getting to, one thing we hear a lot about, even though it's not, I would argue it's not really the MABCD portion of the process, is we hear a lot about the fact that since we're compliance based, there's nothing, no difference for a multiple repeat offender than first time offender. So no matter how many times you've had a case, or how many times an address has had a case in my system, if you achieve compliance, that's closed. If you then have a new violation, you start afresh in our system. All of the same notifications as it stands today cure periods, notification periods, all of that still remains. I have nothing that allows me to advance that as a repeat offense. The second portion of that is that even though we get into tenant issues percentage wise fairly seldom, that does get a lot of attention because of the fair housing concern. Sir.
You were bringing up, so, my financial advisor I met with was complaining about there's somebody that he just pays the fine and everything starts over again. So there's no way to, he pays the fine, does nothing. There's not a way to then expedite a process to encourage compliance. I mean,
So if the violation still stood, that would accelerate somewhat because you're still in violation, but I have to begin a whole new case. If a violation is remedied in that same, well, there's two pieces to that I hear a lot about. One is if that violation reoccurs, we do not go re-inspect without a complaint. So we may have an inspector who notices that as part of other work and identifies it, self-initiates a case, but generally speaking, we will not initiate until we have a complaint. And then again, yes, now and to the second part of your question, so that's one, that could be one delay, and then yes, we just started a case, so you're right.
the thing is, she brought up never fix it. It was described to me, this landlord he's not gonna fix it, I'm just gonna pay the fine, it's cheaper to pay the fine. And then, they'll drag me into court at another point. That to me doesn't solve an issue, and again, if you have somebody that's actively working on the property, that to me is different. Because you're wanting compliance, so if you have someone that goes in and gets a job done, gets it compliant, that's completely different than the person that's, I'm just, give me court, what's the fine, I'll write a check and go on my way.
Well, and I think that one of the things that we did try to fix in this code was for those repeat offenders. And this code does have graduated penalties, not just from fines, but also with the potential of jail time. And if you get to number 4, this code requires 30 days in jail. Now, whether that's the appropriate sanction or not, I'm just the scrivener for this. But I do think that there are some provisions. One is I don't have to give them time to fix it. If I've been out here 5 times and it's still not fixed, I can proceed to a UCC. I don't have to give them with a notice of improvement. So from my standpoint, those would be the types of cases that you're talking about. We've been here before. Here's your UCC at this point. You're going to go to court. And then if there's the correct level of communication, then my staff knows, hey, this is a repeat offender. We've seen them before. We can shorten or ask that the continuances not be as long. And again, my staff can only ask that a continuance be denied. Whether a continuance is denied or not is up to court. And then we would try to shorten that time frame as much as we could to get that case adjudicated.
Well, I'll take 2 hands and then I want to jump in here.
Who decides who's appointed to this Board of Code Standards Enforcement Appeal Board?
It's a joint board for the city and the county. The city has a certain number of appointments and then the county has a number of appointments. They're an engineer, architect, builder.
Class, so structural engineer, 2 architects, 1 county, 1 city, class A, B, and C contractor, real estate representative, and 2 at-large members.
And that's the city council and the county commission.
Yeah, city council has 4 appointments, board of county commissioners has 4, and 1 is appointed jointly. The class A contractors, a joint appointment.
And then on this new process, can you walk me through, most of the code violation notices we get are exterior, typically tenant driven for failing to mow their lawn or their vehicles parked or garbage outside. So, you mentioned the repeat offenders. How would that process work? Because from a landlord's perspective, there's rights under the Kansas Landlord Tenant Act we have to go through. We can't just remove tenant property. We can't just, we have to 1430. And so can you walk through an example of that process where it was being driven by the tenant not following the lease?
So I'm going to throw something out there before the expert answers this, because you can hit this issue. So as it stands today, and as I go into the new code. So if I give you a notice of violation and you have 10 days to correct that, and on the 9th or 10th day that is corrected, you're finished. You're done. No, the case is closed and we move on. So we would not consider that, you complied with the violation. So if we point out a violation and it's complied with, then we would not really consider that a criminal, you haven't risen to the level of a UCC. So now some of this would be policy that would be looking to you all and city council and prosecutors to direct us on. But if you're tallying offenses, I would not. Now, if I come back out to a notice, I would not necessarily consider this a repeat offense because you did not actually make it to the level of offense.
We are only counting convictions when we go forward. I mean, if you're a landlord and they give you a 10-day notice and you get it fixed in 10 days, we like you. It's the ones we've given you a notice, and we don't hear anything from anybody. I also think that while we're morphing together the nuisance code violations, the weeds, the grass, the junk, the trash, I still think that we will continue to use the abatement processes, that if we told you to clean it up and you haven't cleaned it up, then under the Kansas statutes, we can abate that. We can clean it up for you, and then that goes against the tax rules. So I don't think that we're gonna necessarily get away from abating these properties. And I think most of the cases that we see in environmental court aren't really the tall grass and weeds, unless you just have somebody that's really obstinate and just never do anything. They are more the housing code violations and just how to get somebody to fix their house.
So let's step back for a second. We've got, what I'd like to do is get through A through F. And these were specific concerns expressed about the International Property Maintenance Code. I think it goes well with the conversation. Then after we go through those, I would like to then go broader discussion about, I mean, a lot of issues have come up about should we be more narrow in what we're looking at, some things like that. So I'm going to turn that over to all of you at that point. Garrett, you may want to help us. You and Kurt have basically fed A through E here. But many of these concerns were also expressed by other people during that 6-hour meeting that we had. So if the first one had to do with the role of code official, would seem to be expanding the role of the inspector / MABCD director. So I'm going to maybe ask you to tee it up, and then we'll hear from others as well. That's okay.
Sure. I think a lot of the question really came for understanding how the process would be changed when it comes to MABCD and the role of the code official as opposed to how it currently is now. I think a lot of that was, and I know we said we'd address it maybe on C, but how that works in conjunction with not having an environmental court, whether that all goes through MABCD or some other agency, whether it would be MABCD that is actually in their staff that are the ones that are actually doing those inspections. You hear all kinds of things that people say that they heard from somebody, but whether that's going to be farmed out or whether that's going to be all in-house or not. So I think having more understanding of is it growing that office or is it changing that office significantly or not?
Yeah, I don't know that we're talking about growing the office. I'm not sure I have bosses that want to know that. Yeah, in fact, I'll help pull chairs up there. You might as well stay up front, so.
The amendments to get rid of environmental court, these cases are still going to go through municipal court. It's just not going to be the neighborhood problem-solving court, which was, if you look at the ordinances in chapter 1 and the charter ordinance that started neighborhood court, it was to be a more problem-solving court. And I think the goal of repealing those ordinances is really to have this be focused as much as it can be on a traditional court. You violated the law. We're gonna give you a little bit of time to get it fixed, kind of like we do sometimes with driver's licenses. Gonna give you a little bit of time to get it fixed. If you don't get it fixed, then we're gonna have trial. Or you're gonna plead, or you're gonna do whatever you need to do. And get away from the cases that have been pending. And I'll be the first to admit it, a year, 2 years. Some of that is because we lose the defendant. I show up to the first 3 and then it's, oh, you really mean business, and they go out on warrant. And it takes a while to get those people back in court. But I don't think there's anybody in this room that doesn't think that environmental cases are not still gonna go to municipal court. So the goal is not to have MABCD be the prosecutor and the judge and everything else. We have this limited appeal process, and then the rest is still gonna go through municipal court. The goal is just to hopefully have those municipal court resolutions done more quickly.
I do think there's a change in the policy direction from the council that what was built into that ordinance is not based on community feedback and neighborhood feedback they get over and over again. I think they want to take some of that ability for continuances or continuation out of the process, because there was a feeling that with some property owners, they were using it as a tool to not address the problem, and too many neighbors are concerned.
So there would still be a UCC complaint and it would just be assigned to, are you just changing the docket essentially, eliminating that docket, or is it a little bit more? Than that?
Where these cases land on the docket, that's a judge's decision. I would be surprised if there's not a case exclusively or primarily for these kind of cases. You're just not gonna have a separate neighborhood court or accepted environmental court. You may still have a nuisance docket or a property maintenance docket, but you're not gonna have that environmental court concept that we're problem solving for.
In terms of the specific responsibilities of Chris and his staff, do you want to address any changes you think are there, or is it just really in naming and the way we worded things?
I think that's correct, sir, that, yeah, there's, now, this opens, conversation up, opens a discussion up as to would we prefer different approaches, different directions in a few areas, but our basic processes and what we do, right, very little change.
Yeah, I personally don't, this talks about city manager appointing a code official. Frankly, that's the MABCD director. We could clarify that if that was a sticking point.
I don't know who's first.
I just was curious if you could kind of talk a little bit about how many code officials you have, and kind of their workload already. I assume that you just by going throughout the city that you guys probably already have more work than hours in the day. And you know, when we're deciding on these decisions, once these are implemented, people are going to want to see change. And then I was also kind of curious what your turnover rate was on there. Myself, I'm a landlord. I also have my GC license, and although you're saying that we're innocent until proven guilty, a lot of times I feel completely different when I'm out in the field with the boots on the ground. And when you start reading through building code and stuff, you have your code, but then you have like a lot of exceptions and a lot of different things that you have to take into consideration. A lot of times, you know, when we argue these things civilly, you know, we're using these exceptions. And what I found is that I'm dealing with a new person every time. And so when I'm on this board, I want to, although I have the knowledge to be able to say, hey, like, I understand what you're saying, but let's look at it this way. And most of them are probably not your problem child, but we're here to represent everybody. And I just was curious, he's saying that we're not going to implement any more boots on the ground, more than likely to this. And your people are already super busy. Doesn't seem like a very fun job to me, very ungrateful job by most people. Just kind of curious what your turnover rate is, how many people you have out there, and how you expect to implement all these things once they're out and about.
Right now, we're in pretty good shape. We have, in the last 5 years, we've had quite a few retirements, and we have had some just leave. It is tough work. Thank you for acknowledging that. So in MABCD general, we have 3 divisions, sections within those divisions. So one is building and inspection, and that's what you referenced as far as building codes, permits, licensing of contractors, all of that. So that's things being built. We then have the administrative section, which oversees the actual issuing of permits, licenses, and, ensures contractors' insurance and all of that is staying up to date, manages all of our money in our systems. And the neighborhood inspection, which would oversee the IPMC and everything associated with that. So that is a section of 21 individuals, 15 inspectors, 2 supervising inspectors, for that group. There are the 2 social workers, the code liaisons I discussed, and then there's a neighborhood administrator, or neighborhood code enforcement official. We just renamed that. And then we've got 4 program managers that oversee. So an example of a program is illegal dumping. So we have clerks that one clerk oversees illegal dumping and tall grass and weeds. So an illegal dumping complaint comes in, that's given to an inspector, data comes back, it's given a work order, sent through, so we charge, Public Works pays those bills, contractors pick it up. So that would be an example. That tall grass and weeds similarly. So the work is assigned to an inspector. As that data comes back, it's then assigned to a contractor. So we do have staff that manages those. But yeah, so to boil it down to the staff that you're working with, again, right now we're in pretty good shape and we've stabilized a lot. I do appreciate the feedback about seeing a lot of new faces and sometimes feeling like, they're catching you after they've already maybe had enough for the day. That we always try to work on and train with, because it is tough work. So to break that down a little bit across those 15 inspectors, we average about 9,000 cases a year. We do, so neighborhood inspection usually gets about 25,000 inspections a year. Gets about 25,000, no, it's about 35,000 phone calls a year. And then that's on top of all of the normal human resources and, other work that we would do. So it is very busy across the department. The highest I've ever seen is we did 123,000 change inspections in a year. We do about 30,000 permits in a year. In total, we get 85 to 90,000 phone calls in a year. So yeah, it is a very high volume, high transaction department in that regard.
Do you feel like you have enough resources that when we do implement this, that you'll have enough staff to support it?
And see, that's a great question, actually, because so one thing we have done is through the budget process with the managers and the council support and requests, we have greatly increased over the last 4 or 5 years the amount of operational funding we have in order to do the abatements, to do the actions that we're allowed to do, because we had more staff than we had abatement money for. A lot of that emphasis was placed on working with property owners to gain a level of compliance, that voluntary compliance. We have shifted that to be much more aggressive with moving towards abatement. And so we have found the point where our funding for that is it maxes our staff. So if we spend all of the money that we have to do forced abatement or forced enforcement type actions, it's all that staff can handle right now. I think we're kind of at that level. So now speeding, there are a lot of different ways to look at that. If you look at our voluntary compliance, anything we do to put more in the pipeline gets a lot more compliance because we're still getting 85+% of those to go ahead and take care of the problem before we have to deal with it in this way. So that is one piece to keep in mind. But yes, so we're looking to shorten timelines, as we discussed here, shorten timelines and to create better outcomes, if that's stated properly, without really increasing staff or funding for the abatements. So hopefully that makes sense.
My presumption with this, and this is just kind of continue on with what he's saying is, and I do have a question for you. I don't see that this increasing the need of staff. If anything, it gets people cleared through the system, hopefully quicker, so that it's less burden on staff. Because right now, staff is gonna respond to known issues or complaints. This isn't a mechanism that's gonna increase complaints, because you're still gonna respond to them. And if you can clear them in a more permanent way, it should take burden off staff time, I would hope.
And that's one thing that Troy's talked about quite a bit when he's worked through this, is a look to go more of a permanent fix, more of a, we're not going back time and time again, because we're keeping these open and allowing multiple bites of the apple.
So what about consistency throughout the employees? So a perfect example is I got a call on a waistline. When they finally pulled permit on it, there was 4 different inspectors, and 4 different inspectors called out 4 different issues, when the first one should have actually just called them all out so that they were all replaced at the same time. Are we gonna have with this a little more consistency on, we're inspecting to this point, and that's gonna be consistent throughout the write-up process, or are we gonna continue to take it further the next time we come out?
Yeah, so 3 points. Number one, to continue to build on real simple math, right? If an inspector is going out to the same property time after time after time, if he's going to the same property 6 different times, he's only addressing 1 property. If you go to that property and you only have to go to the property 3 times, in a matter of 6 inspections, he's now gotten to 2 properties, right? So the efficiency and the efficacy of this model, again, reduces the burden and expands the scope so that we can actually get to more properties in a more efficient way. To your point about standard operating procedures, yes. So the next iteration of these conversations is, once we know what the codes and ordinances are, then we can continue to build and fine tune those standard operating procedures. You're right. Right now, one inspector might go and respond to a property one way, because the standard operating procedures are not as quite clear of what does it look like to address this violation. Might go out to a property on one day and give this property owner X number of days, versus walk down the street, same violation, and give that property owner a different number of days. Right? We want to standardize that, and that's going to take some training, right? And we're dedicated to, once the code and ordinances are in place, we're already in the process right now of drafting those standard operating procedures based on where we think this is going to go, right? So we're not losing a lot of time, but then ultimately there's going to be a period of training that's going to have to take place to make sure that each inspector is enforcing the codes and ordinances as consistent and as in a quality control manner as possible. Absolutely.
As it reads, though, the code official has a good amount of judgment call in this ordinance. Like, there's a lot of areas where it says they can do this or they can do that. And so essentially you're planning to address that with the standard operating procedure at a later date. So I think that's one of the issues that created a lot of like pushback from landlords, is like that gray area that is being presented, where, you know, we can all sit here and speculate all these different scenarios, right? It all happened or have happened or will happen. But like, to kind of narrow that gap, I think that would give more clarity. One, I had another follow-up. I was just curious, like going back to the placard thing, how many of the 15% is it actual homeowner occupants versus landlords that are non-compliant?
I don't want to lie to you there.
Is it 50-50? Is it 10%?
I was going to say probably 50-50. We tend to have, let me back that up, not quite 50-50. We tend to have more problems with tenant occupied properties than we do owner occupied, but it's not like a 90-10, you're 60-40, somewhere in that.
Because the placard just seems like you could just, because if that landlord is only in it for money, you making the property uninhabitable, to where they can't collect money seems like the most like instantaneous force of action.
Yeah, that tends to be one of the more effectives. We do have, sometimes we find some interesting things there that bring people in anyway, remove our placards, so we try to catch that stuff. So a lot of this does come down to training and potentially, a mistake. Inspectors do make mistakes. But generally speaking, and I think especially in neighborhood, the policies tend to be, more solid, more, X equals Y, unless the supervisor or myself, makes a change. So the sewer, plumbing, it sounds like example there, maybe I got lucky and it was actually a public works inspector on the sewer side, but if that's MABCD on the plumbing side, then when you get in a situation like that, that inspector gets to have a conversation with their supervisor. A lot of times that happens in my office. It's not a good day for them. Because exactly that, they should go out and note every correction that is required. If we do miss one, we've got to go back and fix that, but it should be consistent. And when we catch those, we try to fix the training. If there's a policy gap, we try to get that fixed right away. So to that, I don't find or see anything in this code that gives me more authority than I have today. Maybe it changes the approach that is taken once that violation is noted, and maybe accelerates some of the timelines there. You could argue maybe that's more authority, but it's really trying to streamline it towards the correction, I believe. And then again, we have known for a long time that our codes had not caught up with organizational shifts. And so by getting it updated and streamlined, I think you will see it easier for us to maintain consistency. If for no other reason, we won't have a situation like we sometimes do now where I'm not sure. I have to have a conversation with Gary Jansen as to whether it's going to be Public Works or us who should go take care of the issue. So that will greatly help in those areas.
The meeting, the original said 2021 edition, we're going to 2024, which I would prefer anyways. It's much simpler. Is it 2024 edition of the IPMC?
2024.
Yes.
When you say it doesn't give you more authority, section 105.3, the right to entry, access properties, is that a right you currently have?
Yes.
Yes, we do have right to entry does not equal,
One inside.
yes, does not equal, entry, or we still have to meet the criteria. We can't violate the Fourth Amendment of the Constitution. We consult with legal, I would say, on a daily basis. If not daily, almost daily, we consult with them on those type of issues. So, because we do have to have legal, so we have a right to enter or right to access, but it still has to be done legally. So either with the landlord's permission or the occupant's permission. And yeah, there are a lot of times, it's one thing that brings this conversation to the table. There are often times that we tend to lose a case. That's not the right word. When I say lose, isn't the case the case goes away, ends up being closed out. I don't want to imply we're losing it in court or something like that, but we kind of lose momentum on a case because we lose access.
So you lose access because the landlord or the tenant no longer give you permission to access the
Correct.
property?
We no longer have a legal method.
And you get access through an administrative warrant?
Unless we go to court and get a warrant. Yes, sir. Thank you. Very good point.
Yeah. So
And so
it can't be shut off by those two if we can get it from the judge. But you can't just simply walk into a unit.
Correct. If we did, it would be like any policing type action where none of that's considered admissible or usable or can be used as part of the case. So I would defeat my own purpose because at that point, nothing we've seen would be usable. And I really appreciate the manager's point on that because, yeah, so a lot of the look to this is to not to gain us, not to gain some level of authority that we have now, but to try to seek better or different outcomes, seek a corrected outcome. So do we want to emphasize more on warrants? And do we want to put an emphasis there and try to more so target those small percentage? If I'm talking multifamily, tenant occupied properties, do we want to put more emphasis there? Trying to get legal access into those to deal with those versus the way we work this now. I mean, something I'll just throw out to the body, when you talk about court and adjudicated, if you put yourselves in my shoes, take something to court and it is adjudicated and the case is closed in court, but there are still open violations by my code. That puts me in a really interesting spot. Right, so if I go out and re-inspect, am I inspecting something that the judge said was okay? Or should I go out and re-inspect? So it gets us in a lot of really interesting ground when we look at these. So if we start down the road of what is it we want to correct and accomplish, and we define and refine those tools, that helps me know what to do.
Yeah, so these proposed ordinances, they don't necessarily expand your power from an inspection, but they do, if something is adjudicated, it does expand remedies that the code official would have in order to make repairs and remedy the property, actually go out and physically do it that they currently don't have. Is that accurate?
I would say yes, that's possible.
That's correct.
It opens that possibility, yes.
I want to stop for just a second. I think we had listed 4:30 as a stop point. If you're all comfortable going to 5, more than happy to do that. Okay, we'll just keep going then. We okay then in terms of some of the questions that were out there on the role of the code official? I appreciate that. I'm wondering if it makes more sense to talk about C before we talk about fines and penalties. Is that, I know we've started to touch on that. We've already had some discussion of that. I know, Garrett, there was some talk, continued talk about environmental court. Why don't we go to C and then we'll get into the fines and penalties.
Can I ask a question?
Try to keep it to the committee right now. I think there'll probably be a time when we will allow for public comments to the committee or task force before they make recommendation. But I think right now, I think we want to get through these issues. Questions on the process? That's some outstanding issue.
Is there a I mean, is there, without trying to read through this, and obviously we benefited by a couple of lawyers on the board that comprehend this at a different level. Is there a flow chart or something that visualizes what that appeals process is? Because it does, I mean, as you guys said, it's multiple layers and steps to it.
We can, that's easy for us to do, Paul. We can put together a flow chart under the proposed code on how this would work.
Yeah, I mean, perhaps something that shows what the current process is like, which sounds very extended, which we know, and then something that visualizes, it shows how the proposed would be in differentiation between that, especially with timelines. Because as you know, as was mentioned earlier, the council and all of these boards tend to give people a tremendous amount of latitude. I was here, and it's almost 15 years ago since I was here. We have cases that would be coming back to us for condemnation for like 2 and 3 years long. And we'd give people at the bench another 90 days or 6 months. So there's not a process without a lot of latitude given to people. But we also had the people come in here where it's just the same guy who has 50 properties in plain view and never takes care of them. And at some point in time, you get tired of messing with those guys that really show no effort. But if we could show how this process would, in comparison, contrast to the existing process, would probably be beneficial. Same thing with the fee structure, because that's also a progressive system. I'm sure the existing one's outdated and the fees are pretty low nominally compared to what they are today.
It's okay with the committee. What we'll do is we'll hold off talking about B and C unless there's some issues you want to throw out on either of those. We'll provide a flow chart of today's process versus the proposed along with timelines. Some of that's going to be, it could be in a range right on timelines. And then we'll go ahead and get you the fees and penalties today versus the proposed. We'll do that.
You're going to give timelines too? I bet there's still people from when.
Timelines on the penalties.
Yeah. And I think the weight that would be passed on the court system if we actually are taking more administrative action to be more aggressive with the bad actors, to me, that's the critical part. But if the courts can't handle it and it's 15 years till it gets addressed, then people are still living in shitholes.
So we can talk about that. Our initial thoughts through this, Troy, you can help me, is that we believe that if this gets successfully implemented, we'll actually take a little burden from the courts because fewer actions will get to them and there'll be fewer continuations of cases. So we even got to a point where we wondered eventually down the road, would we be able to take a one court out of our system? Not sure that would be an immediate reaction or response, but is that accurate in terms of?
Yeah, I would agree. If you go back to kind of what Sharon was describing about kind of how neighborhood court and court was originally designed, right? I mean, it was that problem solving, it was that continually monitoring, and it's become an exponentially more streamlined process in the sort of judicial system. And so along the way, we've tried to streamline and expedite this from enforcement to prosecution to even the adjudication process, right? That the idea is to try to streamline this across all platforms.
And then in all the court systems, can we adjudicate without an out-of-state player on the premises? Like if I'm in eviction court and I can't get to eviction court,
I mean,
the landlord wins usually.
unless I can get somebody served, we can't get them to court. I mean, and that's the problem with
The registry.
the registry. Is, you know, if you had a registry, you could make out-of-state owners at least designate someone locally or within however many miles. And there are lots of, and I know I don't want to go too far afield here. I mean, there are lots of different versions of rental registry, and I picked one. There were a couple different options. And some can be no more than tell us who your person is. That's it. We're done.
Can it be done only for out-of-state operators?
Yes. Or I think it would be better from a constitutional standpoint, look at my lawyers over there. If you said you didn't live within either Kansas or within a certain radius of the city, and there's a lot of cities that say if you're not within 30 miles, 60 miles, so then you have a real nexus for you're not here, you're not local, that's why.
How would you get them to actually register? They're not willing to fix the issues. How are you gonna actually get them to comply with?
I think you have another violation and you use whatever means those are, whether that's a private, we've had some discussions about this, a private process server. Can you serve by publication? I mean, there are other ways to serve some of these people. But you are correct. At some point, we have to figure out who that person is, who that owner is.
One of the things that I have a concern about was a comment that was made earlier, which I've heard a million times, and that is that the penalty isn't strong enough for that out of town owner. They'd much rather just pay it and move on. And I don't know how much of that happens, but that would be something that we probably want to, if we're going to go in that direction on dealing with the problematic out of state owners, how do we make it so that it's really difficult on them if they don't take action?
I'm not a lawyer, but I would think that in the time of transfer of ownership, so like, you know, the title company collects information from a seller and a buyer. Like, is there a way to make an ordinance that requires that title company to report their contact information?
I'm going to say probably not. I think you're going to have all kinds of confidentiality issues. I mean, we can get documents from the Register of Deeds that are going to show who signed the last contracts that were involved. We have a lot of contracts for deeds. Those are never even filed across the street until we try to serve the person. And if you look at our definition of owner, it's really, really broad. And it's really broad because I wrote it 10, 15 years ago because I wanted it to be as inclusive as we could. And some judges have liked that and some have not. But I do think we do try to make sure that if I'm the person that bought this and it's shithole, as we said earlier, and I just have a contract, but the deed's still in his name, who do I go after? And we try to be able to go after both of those people, quite frankly, to try as have a broad as net as we can to get the right person in court.
Help me understand this, because obviously the thing that got everybody's attention was this was related to rental properties initially, but a lot of the stuff we're discussing is
All properties.
It's
all-
across the board.
And so,
The only rental property piece that was presented to the city council was the rental registration. Everything else was across the board.
okay, and thank you for clarifying that. But nevertheless, as we look at this, when you got, Mr. Labram said about 50-50 on participation on those 15%. My presumption, just being a layperson, is that the out-of-town people, the out-of-town owners that no one can find are probably more related to dilapidated housing that's not occupied by a renter. Because if you have a renter, somebody's paying somebody somewhere along the way. And you should be able to find them, whether they're being paid directly to the owner via check or ACH or however they manage rent, or it's being paid to a property manager. And so my presumption is the out-of-town people that are harder to get a hold of, is that related more to just the dilapidated property versus the rental? And would a rental registry really help in regards to that?
As far as numbers, I'm gonna have to defer to Chris, but my thought is it does apply to both, and because they bury the LLCs. So I'm the tenant, I'm going to pay Paul Gray LLC, and then Paul Gray is really just a company in Oklahoma who goes and collects for Mr. G. And Mr. G has a company that has one LLC and then another LLC, and for his folks or my staff to try to track that back, it makes it really, really hard. Where if you had your rental registry and you would say, I'm gonna rent this to you and I have to tell you, city, who my responsible person is. That person's not legally responsible, but that person is responsible to accept these notices that we're giving and accept the criminal complaint. And at least you get service on somebody. Is it gonna solve all these problems? No. Could it help? I think it could.
Don't you already have that in place when you file for an LLC? You have to have a designated.
Registered agent.
You have to have a registered agent. And again, a lot of those registered agency is a lawyer in Kansas City or a lawyer in Topeka.
Why can't they be served?
If you're serving them.
They never celebrate
Again, you have the problem of getting a person into court. I mean, I can serve a notice to Topeka, but I have no way to get that person here. Where we have some mechanism, if they're a responsible person in the city limits, we have some means to get that person back in court.
What about that new thing that everybody has to fill out for LLCs that they're trying to prevent? It's a federal, I can't remember the name. What's it called?
Beneficial ownership, but
Yeah.
they nixed that.
As they,
And it
they
wasn't-
already
I
have
don't
that.
think it would have been applicable to use for.
On the
like this.
penalties piece, could we just very quickly look on page 15 on the violation penalties? Because, I mean, the process you've described seemed a little different than when I was reading this the first. This says, any person who shall violate a provision of this code or fail to comply with any of the requirements shall be prosecuted within the limits set forth of the code. Each day that the violation continues shall be a separate offense. And then it goes on.
And that's in the current code now.
Are you talking 107.3?
Yeah, we're on page 16
Oh, 16.
of the,
107.4.
Yeah, and so that violation, so if I pull up, for instance, one on the ones of not having scattered debris, 308.12, you're not allowed to have refuse or junk. So is that technically is a violation, correct?
yes.
And
And I think that's one of the things that I think if I heard anything from the conversations from the bench on both the rental registry and this piece, Or do we want to separate out, like they are now from a penalty standpoint, your penalties for the junk and the trash and the weeds? Should those be different from, I have a house that's falling down?
Sure, but even in the case of something on the inside of the house, like if there's a violation, I mean, the way I understood the process is you typically give us some time to fix it. But I don't see that in the language here. So can you show me where in the language here it talks about, yeah, there's a violation, but we're not gonna hit you with these fines or convictions. You're actually gonna have a period of time to fix the violation and you won't be subject to these fines. Can you?
It says or fail to comply. And so that's what we have 80 to 85% compliance. That's all you good guys. What you guys, I don't know if you see the bad guys. 31,000 families in our community live in a house with, don't meet the minimum housing standards as set by HUD, which are very minimal. Hot and cold water, electricity, a working sink in the lavatory as well as the kitchen, 3 appliances.
And I agree.
And I know the people steal the appliances, they steal them from me too. But gotta find the thing for the 15% so that they're out of here. Or you can buy 4,000 more properties, Francis, please.
And I don't want to do that. I'm just saying, yeah, I think we all agree that those situations need to be addressed. But I think on the flip side, what we're just trying to prevent is, I mean, when I read this, it says, if I don't do any of those things, it's just an immediate violation.
If you go to page 26, section 109.4.1, you're going to have an initial notice of violation before you get to a UCC. That process isn't going to be changed. What has been changed in the code is the requirement that you have to be given time to fix it. And again, I don't think that it's the MABCD's intent, and I don't speak for them, but that they're going to go out and start issuing immediate UCCs to everybody. But I think we did need a way to streamline those cases that needed to be streamlined for the repeat offenders. That we've given you the 30 days, the case gets closed in municipal court for whatever reason. Chris has to go back out, look at it again. We have to give you another 30 days. And by taking that provision out, we would not have to do that.
And then I'm fine with that. I just think the language probably needs to be changed because the way I read it, you would have the right. I mean, this just says you give us a notice, but it doesn't say that we're not going to be fined if we get a certain period of time to address the issue. I don't see that in here.
Yeah, I agree with his statement. That's a lot of my reservations. It's the language vagueness on some of those points. And then.
Okay. All right, so we'll go back and read this, right, kind of from your perspective. But as the International Property Maintenance Code is drafted and is written, right, it's industry standard best practice, whether it's building code, fire codes, right? If you're given a notice of violation, right, that's that initial, you are notified that you may be in violation of city codes and ordinances, and you have a period of abatement, right? The inspector can't assess penalties. Only the courts can do that, right? So it's not as if the inspector can go out there and say, you're in violation, you owe $400, right? Only the judge can do that. So only the conviction, only the actual violation, innocent until proven guilty, right? I can give you a notice that based on my inspection of the property, that you have grass taller than 12 inches, right? I have to go convince a court that you were in violation of the codes and ordinances. The inspector can't determine whether or not you're guilty.
But a judge is going to look at this.
Yes.
The judge is going to say, any person shall violate the provisions if they fail to comply with it. So that's going to be, the judge is going to be focused on this language, and it says that's a violation. They go to that section in the back, and any small thing, like there's no language that says, but it shall not be a violation if they promptly remedy the situation.
And I would do like that. There's the notice violation, there's an abatement section, and then there's some other language in there other than that one section that talks about.
We'll come back.
Yeah.
That's a good point, and we'll come back next time that we meet on that.
I have one more thing to that. In 7.3, why was it stricken or civil infraction removed? Is there a reason that civil infraction is not a viable option anymore instead of just a misdemeanor? But it's on that same page, 15, 7.3, prosecution of violation. It said misdemeanor and originally it said or civil infraction as determined by local municipality.
And that's language that is in the IPMC. Currently, we don't have a civil infraction in municipal court. There's a difference of opinion in lawyers across the state as to whether you can. I'm not sure that I think a municipal court has civil jurisdiction. So we would need to work on those charter ordinances if that was something that we wanted to do and create a civil infraction. And that was why that.
I did just have one more in the same section. So the proposed code does say that it makes it a strict liability offense. What is the opinion of, I guess, the city as far as making it strict liability? To me, that means that if your time on your that notice of violation runs, then you're going to be held strictly liable to that. And that really is going to prevent any judge or from having some discretion as far as was that a tenant cost issue? Was it, what were the circumstances and whether this owner is going to be guilty or not if you're making it a strict liability offense? Is that currently in the code or is that something that's different or new?
I believe it's currently in the code. It doesn't say strict liability, but I view that as being an intent issue. And if it's the desire that that be cleaned up, it can be, but I don't have to intend to let my grass grow. You don't have to intend to have a hole in my roof. That may be negligence, that may be obstinate, that may be, I didn't know there was a hole in my roof. And that just goes to the intent that needs to be proven for a violation standpoint.
It's probably a good time to stop for today. Again, I know we've, got a timeline and I'd like to keep it moved. Would propose if objection, that our next meeting be a week from today, November 12th. And then we could do it over the lunch hour. We can start at noon. If that's okay, we'll provide you food. And then we can maybe go to 1:30. That'll work for everybody.
So 12 to 1:30.
I think we had one person who indicated they may not be able to attend that day, but I know we're not gonna be able to get all 15 every time. If that's okay, we'll go ahead and, okay. So back here on November 12th at lunchtime at noon. Anything else you want us to do in advance of next week? I think we've got some homework from you that we'll bring back.
Can I talk real quick about the implementation timeframe?
Yes.
Because there was, I think.
Yeah, that's an easy one to get off the table. Yep.
The overlap in the codes, if you look at the package that went, there's a sunset provision to essentially repeal chapters 8 and chapter 20. So it was never the intent that these were all going to go on forever and ever and ever. The overlap was to allow time to get notices printed, UCCs printed, computers programmed, not gone through municipal court computer programming, and you want to say it's going to take 90 days and it takes 3 years. So to allow some of that overlap. Title VII is not in this mix yet because there are still some provisions that Public Works enforces. And we need to go through, we need to ferret out what those that need to stay and what those could go and are duplications in Title VIII. So it's never the intent that we're going to keep dual requirements. And I think that staff is flexible in what that overlap needs to be. We chose January 1st, but I know was an issue. That date was chosen when we thought we were going to be on the council agenda in July. But again, priorities get shuffled around.
So we've got flexibility on that. We'll seek your guidance on implementation whenever when we get to that.
Are we permitted to reach out to staff in advance of the next meeting?
Oh, please feel free to do that. We're all available. Everybody that's here is available. So.
This is just like every other advisory board, when I served on the alternative transportation board, we can contact
Sorry.
anytime. This is just like any other advisory board, like the alternative transportation boards and so on. So
Well, thank you so much. I hope you found this productive and discussion and giving you additional information to help grow that team. Thank you, everybody.
Yeah, you too.